Namaskar, I am Assistant Professor Kritika Dev from LG School of Law, and today, you remember the part 1 of culpable homicide and murder? I stated in that session as well that this is the part 1 and later on we'll be dealing with part 2. So this is the part 2 session of murder and culpable homicide. So without wasting time, let's move on to the sections. So here, as you can see on your screen, we have discussed in part 1 also. So let me just tell it to you. And here it is, culpable homicide amounting to murder, that is section 300, which we will read it as murder, right? So in short, we call it as murder, and we will see culpable homicide not amounting to murder, that is mentioned under section 300, and the section 300 of course, but the explanations from 1 to 5, those are culpable homicide not amounting to murder. So here the punishments are being given for section 300 under section 302, right? And when it comes to the explanations, culpable homicide not amounting to murder, the punishment is being given under section 304, right? So different punishment for these two things. Now let's see what do we understand by murder. So murder is being given under section 300 of Indian Penal Code. The definition says, except in the cases hereinafter accepted, culpable homicide is murder. So as we have seen, exceptions are being given from under section 300, 1 to 5. Those are the exceptions where the person would be liable for culpable homicide not amounting to murder. But let's see what is murder, right? You remember in the last session we have seen that here it is the culpable homicide, that is the genus, and here it is murder, the species of culpable homicide. And as I stated in the last lecture, that it is the aggravated form. Now how is it aggravated? That we will see under this section. If the act by which the death is caused is done with the intention of causing death. Now here the term death with the intention is similar, right? But the gravity here, it differs. Now how does that differ? First, say if somebody, as I had the intention to kill somebody, or you can say A had the intention to kill B. Now A just hit B, right? A hit B with a with a uh, with a with a wooden stick, with a big wooden stick, and then he dies. Or here, there we can say it may lead to culpable homicide, because the difference, the basic difference, I won't say difference, but the aggravated form that you'll be able to see is even with the weapon, the kind of weapon which is being used for killing somebody. Or you just take the second example where A just triggers the gun, and due to the bullet on the head, B dies. So of course that is an aggravated form. Shooting somebody on the head, done. But hitting somebody with a big stick, with a thick big stick, and then that person dies. Of course, even you as a prudent man can find the gravity, the difference. Or the same thing you say that somebody with a rod stick hit somebody 10 to 20 times on the same place, that too on the head, then that is the aggravated form. You're getting my point? Of course, the person is dead only once. That is not the thing here. But it is an aggravated form. Correct? The next one is if it is done with the intention of causing such a bodily injury as the offender knows to be likely to cause the death of the other person. So here it is the knowledge. So now here let's take the knowledge as in, first say if it is offender knew that that person is already suffering from something, right? Or we can say that person had gone through a surgery or something like that. So he just had the knowledge that by giving that very thing, by giving that very blow, he will die. So if it is done with the intention of causing such bodily injury as the offender knows too likely to cause the death. So he had the special knowledge here that A here, supposingly A had gone through a head surgery or anything. So even if he'll put one single blow of anything, that person would die. So he had these special means. So that special means here also lead to that very offense. if it is done with the intention of causing such bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course. So in the ordinary course, the blow is sufficient, right? In the ordinary course, as in, let's take an example. For say, let's take the previous example only. If somebody, previous to previous example, the rod thing, right? Now, in the sufficient nature, in the sufficient course, it is known to everybody if somebody will hit with a rod stick 20, 30 times, right, then that injury is sufficient in nature to cause the death of the other party. So that is sufficient in nature. Here, keep this third point in mind, and we are going to read a very interesting and a landmark judgment. That is R versus Govinda. It is related to this sufficient nature itself. That we will read in detail, right? Related to this third point. Now, the fourth point is, if the person committing the act knows that it is so imminently dangerous that it must in all probabilities. So here the term in all probabilities makes it more aggravated. So you see the extended version or the aggravated version of culpable homicide. Right, so it is of course the genus and the species connection, but it is more aggravated. The kinds of weapons which are used and the way the death has been caused are of course relevant to make that basic difference between culpable homicide and murder. And I said, as we will be discussing R versus Govinda, which is a very interesting case. So here you can see, murder, as I gave you the example, shooting somebody on the head directly with the gun. So of course you had the intention in directly shooting, it means the person would die, and you had that very intention to kill that person. And on the other side, hitting somebody on the head with a wooden stick, there is a difference, right? The forms are different. Of course, cause the death, but difference between culpable homicide and murder. So as I was saying, we will discuss this very interesting case, that is R versus Govinda. Now what happened under this case? There was the accused who had a fight with the wife. Now what did he do? He just put his knees on the chest of his wife. He put his knees on the chest of his wife, and then he punched her thrice, 2 or 3 times on the face continuously. He punched, right? No weapon, nothing. He just punched, and due to clotting or some blood circulation or something, the women, there was no fracture and all, but maybe the clotting, the blood clotting in the brain, or of something of a medical language, the women died. Now, when it came to the lower court, convicted him under section 302, that is the punishment for murder. But later on, when it went to the apex court, the apex court stated that if a man hits somebody or punches somebody on the face, it is not sufficient in the ordinary course to cause the death of the person. You remember that third point. In murder, the injury should be sufficient in the ordinary course to cause the death of a person. But the apex court has stated that in ordinary course, punching somebody on the face for 3 times will not cause the death. So in ordinary course, it will not cause the death. So he might have had the knowledge, but it is not sufficient in nature. So therefore, he was convicted and the punishment was given under section 304. That is culpable homicide not amounting to murder. You see the very difference? It was not sufficient in the ordinary course to cause the death of a person. Punching somebody, I don't know what happened actually. The clotting thing, of course, had happened, but it was not sufficient in the ordinary course. So, do you get these simple, slight differences, right? Okay. So now, as I was saying, culpable homicide amounting to murder, culpable homicide not amounting to murder. So here are the exceptions to it. Now the exception says grave and sudden provocation. If first say A murders B, but A murdered B due to sudden provocation. A murdered B because of the sudden provocation given by B. Right, he was abusing and he was saying whatever he wanted to say and everything like that, or anything, any kind of provocation which is being given by B, and because of which A killed B. So of course he will be punished, but he will be punished under section 304. right? But there are certain things which we need to keep in mind when we see grave and sudden provocation. Now, what are these things? Not voluntarily provoked by the offender. So here we are talking about provocation by B. But this provocation should not initially be given by A, that A provoked, then B provoked, and because of which A killed B. So initially it was A who was at fault, so it should not be provoked by the offender himself. Correct? The second point, not given by anything done in obedience of law or lawful exercise. So if a policeman actually gets hold of a criminal, right, and just takes hold of the leg or hand and gets the collar of the criminal, and then the criminal says, I was provoked, how could somebody catch my collar like that, and then he kills the police officer. So because the police officer was working, it was done in the obedience of law, it was the lawful exercise of his power. Getting caught of the culprits is his job. So this should not be the defense of the criminal. The third point, not given by anything done in private defense. Now, for say, let's take A and B example. If A B was acting in private defense, right? He was acting in private defense, and when he was, for say, he was A did something, and he used private defense. He pushed him or something like that. So A was acting in private defense, right? Now A kills that very person because B practiced private defense. Then he will not be protected under these sections. So of course, grave and sudden provocation is an exception, but we have these three restrictions. So when these three restrictions are there, if somebody is not falling under these three restrictions, only then he will get the advantage of grave and sudden provocation. Okay. The next ones are mentioned they're very simple, exceeds right of private defense. Now, for say, the right of private defense is being given, right? So, when it comes to killing somebody, there are certain points which are being mentioned, right? And when it comes to private defense, only that much power should be used as it is required, right? If somebody just pull your nose, you will not just go and shoot that person, so you're exceeding your right of private defense. But yes, if somebody is pointing a gun at you and you are also having a, of course, as weapon of private defense, then you shoot, then you can say that if I wouldn't have done that, the other person could have shot me. Anything like that. Right? So you must not exceed your right of private defense. Public servant exceeds the right of power given to him by law. So if anything, if the that is also mentioned there under private defense under other sections, that if they have been empowered, if they have been given some powers and they exceed it and cause the death of the criminal by just in order to get caught of them, then they are exceeding the power given to them. So they will be charged, of course, but they will be charged under culpable homicide not amounting to murder because they have exceeded their powers. Then without premeditation in a sudden fight. Now this very exception is about sudden fight. On the roads you generally see people fighting suddenly without any previous knowledge, without anything like that. Now suddenly if two people have started fighting, there was an overtake or anything, they both stopped, they started fighting, and A or A was there, A pushed B on the road. And of course, there was a green light on the road. So there he had the knowledge, of course, but he had no intention there. So he just pushed that person and the other person died. So that is in sudden, when it comes to sudden fight, he caused the death of the other party. Concerned by a person above 18 years of age. So of course, it is simple to understand when he concerns for the same and the death is being caused, then it will be covered under culpable homicide not amounting to murder. So here is the punishment. The punishment for murder is whoever commits murder shall be punished with death or imprisonment for life and shall also be liable to fine. So here death, of course, could be the punishment, right? Or the imprisonment for life. So any of these two and shall also be liable to fine. But when it comes to culpable homicide not amounting to murder, then death is not the punishment. So when we see the culpable homicide not amounting to murder, person would be protected from death. He will not be given the capital punishment, but shall be punished with imprisonment for life or imprisonment of either description which may extend to 10 years and shall also be liable to fine. Right? So here you see the very difference. The difference here is that when it comes to culpable homicide not amounting to murder, it can even be given to imprisonment of either description, which may extend to 10 years. Right? So, of course, a lesser punishment is there. The provision for lesser punishment is there. When it comes to murder, the punishment is either the capital punishment or imprisonment for life. So here, when the person has committed culpable homicide not amounting to murder, he will be charged under section, or he will be punished under section 304 of Indian Penal Code. Now, with this, I guess the whole concept of culpable homicide and murder is clear. And before ending, I would like to say that kindly watch these two parts together in order to understand part 1 and part 2. With this, I would like to rest my lecture. And as I always say, keep studying, keep revising, take care of yourself. Thank you.